Good afternoon. Two follow-ups from yesterday at the outset. One, an update on the panorama of cases which may be relevant to the proposition at the end of paragraph 20 of Lord Sumption in Ben Kabouche. We are working on a table to cover all the relevant cases there. It isn't quite ready, so we intend to bring it to court at the start of tomorrow's hearing. Update 2. I was asked yesterday, what is the utility of an anti-suit injunction without the possibility of sanctions, particularly contempt? 4 reasons. 1, as we started to discuss, stronger imperative towards voluntary compliance. On the current facts, while not here, Venezuela did take substantial steps by way of respondent's notice and skeleton argument, notwithstanding that the declaratory relief is unchallengeable. The court should proceed on the assumption of compliance with an injunction. The state may take more notice of an order in mandatory rather than declaratory terms. Reason 2, an anti-suit injunction may be more effective than declaratory relief as a shield to enforcement in a third country. Roll the clock forwards, imagine a substantial money judgment in favour of the Republic of Venezuela from the courts of either Venezuela or Curacao, and then an attempt by Venezuela to enforce that in Ruritania. The clubs would wish to meet that not only with declaratory relief, but also with an anti-suit injunction. Hence, the clubs see justification for funding the appeal.
I'm not sure I understand that. The position in the third country would be that this court would have said you weren't entitled to obtain that judgment. That would be the case whether it was declaratory relief or whether it was anti-suit relief. Why would it make a difference to enforcement?
It would have been said in stronger terms, and so I accept that it is about perception, and it projects what the possible variables are in accordance with the relevant rules being applied as to the enforcement of judgments in the third country. But we do say that commercial justification is seen to have that stronger tool to use defensively in the event of that type of enforcement attempt. Reason 3, one also has to consider the effect on third parties within the jurisdiction, such as English lawyers. They may be less likely to assist in conduct designed to circumvent an anti-suit injunction, for example, in relation to providing expert evidence of English law in foreign proceedings. Reason 4, there could be other procedural consequences in this jurisdiction, for example, unless orders. More generally, as we'll see, others agree on the utility of injunctions. There's considerable state practice in favour of injunctions, even though there aren't criminal or financial sanctions possible. As to anti-suit injunctions, particularly, this point on utility is discussed in the article by Guy Wilkes on the Sabah and Government of Pakistan case. I don't intend to take up time with it now, but it's in Authorities Bundle 4, tab 52. Mr. Wilkes discusses the difficulties with contempt in this context, but then goes on to explain how anti-suit relief may still have utility.
What's that reference?
Authorities Bundle 4,
I don't do
tab
numbers.
52,
What's the page?
page 1479.
Thank you.
And it's the final section of that article on pages 1484 to 1485. And Sabah is, of course, the case where there was consent to an anti-suit injunction, and again, deemed utility by the applicant in that case, notwithstanding that there may not have been any possibility of contempt proceedings against the government of Pakistan. So resuming on ground 2, in the context of the judge's findings at 91, 106, 115 and 123, that injunctions are part of the enforcement immunity. When we adjourned yesterday, I was developing the 3 points in my supplemental skeleton. At paragraph 7 to 12, I moved to the second point, which is paragraph 8 and following, core bundle, page 164. We say English materials highlight the distinction between injunctions and their enforcement. The subpoint in this context is that contempt is an enforcement method which is not exclusive to injunctions. I won't show your lordships introductory passages from Arledge, Eady and Smith, nor the CPR, but I emphasise that they make good the proposition that contempt is a more general enforcement method.
So which paragraph of your skeleton are you on?
I started at 8, I'm making the second point now, so I've moved on to paragraph 10. Contempt proceedings exemplify the distinction between injunctions and their enforcement. And at 10, subparagraph 3, the subpoint is that contempt proceedings are not exclusive.
Supplemental skeleton, is it?
Yes. Page 164 of the core. Contempt proceedings are not exclusive to injunctions. They are a more general enforcement method. Indeed, subject to the Debtors Act, there can be imprisonment for failure to pay a debt. For example, where it is proved that the person in question has or had the means to pay the debt. The third point we make here is that penal notices are a red herring. 3 related points to emphasise. A, it is common ground that the penal notice is not an aspect of the injunction. Itself, it is but a warning. B, a penal notice need not be included on an injunction or any substantially equivalent order. Dispensing with a penal notice was one of the workarounds that the court identified in the Sole Bone case in relation to the enforcement of an arbitration award being adjourned on condition of security being paid into court. Again, it's very brief on the State Immunity Act, so I won't go to that, but it's at bundle A1, tab 8, and the case starts at page 212, but the State Immunity Act is dealt with exclusively at page 217. Point C on penal notices. Even if a warning by way of penal notice was included, a state could anyway be protected by the separate immunity against financial or criminal sanctions, as discussed yesterday. So we don't say that's what should happen, but the penal notice itself would not lead to the consequences. Finally, on English law here, we have reviewed the Wolverhampton City Council against Gypsies and Travellers case overnight. We say it doesn't greatly affect any of our submissions, but we do say that the principle that an injunction should be evaluated by reference to a respondent who is expected to obey rather than disobey supports our distinction between injunctions on the one hand and enforcement on the other hand. That is in paragraphs 129 and 141 of that judgment. So in summary, the features of enforcement of orders, and particularly contempt, which underlay the judge's reasoning that the immunity from execution or enforcement covered injunctions, are by no means unique to injunctions as a matter of English law. So much for English law. The customary international law materials also support a distinction between injunctions and their enforcement. On that, I wish to show your lordships 3 sets of authorities, including those relied upon by Venezuela in their skeleton at paragraph 24.2. These will not only show the distinction between injunctions and their enforcement under customary international law, but also help delimit the immunity from enforcement more generally. The first set of authorities are the travaux préparatoires leading up to and then the UN Convention on State Immunity itself. We say the judge was correct at judgment paragraph 110 on the position he set out there based on these materials, but was then wrong and inconsistent.
Sorry, where was it correct?
Paragraph 110. He's dealing with the travaux préparatoires we were about to look at, and he says in the drafting sessions there seems to have been an assumption that according to customary international law, while a state may order another state to perform or refrain from performing a specific act, such orders were of no effect whether related to non-sovereign matters or otherwise. It's a summary of, we say, the distinction I'm about to show you between injunctions on the one hand and enforcement on the other hand. But where we say he then went wrong and decided inconsistently was at paragraph 115, when he then said injunctions were within the immunity against enforcement. And this is...
Where's the bit you say is wrong?
So this is the debate we had yesterday. It's, we say, implicit in 115 in the way it leads to the consequence or conclusion at 116.
I mean, I said it yesterday as well, so maybe I shouldn't say it again. But in paragraph 92, 91, he said, given the clear dictum in Alcom, any submission to section 13.2 is not about enforcement immunity is untenable.
Yes, and we're coming to those cases and why they don't answer the question.
But I thought you'd finished English law.
I've finished English law on the general distinction between injunctions and their enforcement, and then I'm going to customary international law, and then I'm going to the State Immunity Act cases there. So as we go to the travaux préparatoires, for which we start, please, in authorities 4, tab 62, page 1614, we see that the law grapples with a conundrum about the interrelationship between immunity from adjudicatory jurisdiction, or the lack thereof by reason of the restrictive doctrine, and immunity from execution, coming at generally the later stages of a dispute. And here in the UN Special Rapporteur report from 1985, that conundrum is introduced. So on page 1614, there are 2 passages on which Venezuela has relied, paragraphs 12 and 14. And so at paragraph 12 it says draft article 22, entitled State Immunity from Attachment and Execution, deals with the unavailability of means of enforcement of judgments against foreign states in general. Courts normally avoid issuing orders of injunction or specific performance against foreign states, since they would not be enforceable. We'll come on to see how that develops through the travaux préparatoires. Paragraph 14, they also cite, and if one moves about 3/4 of the way down the paragraph, a sentence starts, the last 2 words of the line, by nature, no judicial organ of one state may enforce its order of injunction or specific performance against another unwilling state. The Special Rapporteur then goes on to draw the distinction between the immunity from attachment and execution and the immunity from jurisdiction in the next section. And then at the bottom of 1615, please, the Special Rapporteur explains two extreme positions that have been taken in the past. So the first extreme in paragraph 20 is that it has sometimes been argued that because there's no possibility of enforcing judgment against a foreign state, there should be no possibility of exercising jurisdiction against a foreign state. In other words, absolute immunity from execution breeds absolute immunity from jurisdiction. So that's working.
Where is that?
Paragraph 20 at the bottom of page 1615.
Thank you.
And over the page, reference is made to an Italian writer having said, a sentence which cannot be executed is a legal monstrosity, which is a more colourful way of referring to the paper tiger that one sees mentioned elsewhere. Paragraph 21 goes on to say, as would be seen, the judicial practice of several countries, such as Italy, Egypt, France, Belgium, more recently Switzerland, Netherlands, Germany, UK and USA, appears to have permitted execution against the property of foreign states on several occasions, especially in matters jure gestionis. So that extreme hasn't held. And then one has the other extreme explained at paragraph 22. Another view, differing from the foregoing, has been advanced in judicial reasoning in some civil law jurisdictions. In Belgium, a decision in the Socco Belge case, the court rejected immunity from execution once jurisdiction was exercised on the merits. And there's then reference to a second, earlier Belgian case at paragraph 23. Paragraph 24 says, this view is further reflected in the case law of some countries, such as Switzerland. Immunity from execution is rejected once jurisdiction has been exercised and judgment rendered by a Swiss court against a foreign state. So this is the context for the difficult interface between the restrictive doctrine that has developed and immunity from execution. But in principle, we say they arise at different ends of the spectrum, different stages of the dispute. And that's relevant when one looks at injunctions. At paragraph 27, please, on page 1617, the Special Rapporteur is developing this point on the interrelationship and makes a further point relied upon by Venezuela. In the middle of that paragraph, since no injunction or specific performance could well be forcibly ordered against a foreign state, satisfaction of a judgment debt would have to be sought from among the available assets of the debtor state. So we accept that up to this point, the Special Rapporteur conflated injunctions with their forcible execution. But what we now see is that as the travaux préparatoires continue, the distinction between injunctions on the one hand and their enforcement on the other hand was made increasingly clear, culminating in it being clear-cut in the convention itself. If one then turns, please, to tab 63, page 1622, one has the report of the International Law Commission and that is from the same year, 1985, and what they explain at this stage of the drafting process is that at the bottom, paragraph 230, there's a difficulty in terminology. and that is particularly in respect of the immunity from enforcement. So they say this: several concepts used in the articles of Part 4 gave rise to some concern as to the appropriateness for general application. The concepts attachment, arrest and execution might have different meanings on the domestic laws of states and could therefore be replaced by a general term, such as judicial measures of constraint upon the use of such property, including attachment, arrest and execution.
I'm not sure where you're reading. You said 1622, but I don't think it is.
Sorry, 1623 now, paragraph 230.
It's for the record, there's nothing on 1622.
And at the end of that paragraph, it says the general reference, it was thought, would also include all other measures of judicial constraint under domestic law, including certain types of interlocutory injunctions that might not be strictly considered as attachment, arrest, or execution. So at that stage, the difficulty in terminology is proving particularly to be an issue in the context of certain types of injunction. Tab 64, page 1624.
So are you seeking to show that there's a rule of international law that injunctions are not part of an enforcement jurisdiction?
I am later going to come on to say that they are part of the restrictive doctrine, but what I'm saying at this stage is that the international law materials...
There's a rule of international law that they are included in the restrictive doctrine.
Yes, I'm going to come to that.
That's what you say.
That's
It's a clear rule, not even a tenable view.
Well, if necessary, I'll say a tenable view, but that's at the end of my case on ground 2, but I say I don't need to go that far. And what I'm saying is that there is a clear rule of customary international law in relation to enforcement, and there is the aspect or related rule in relation to criminal and financial sanctions, and neither of them extends to precluding injunctions. That's what I'm developing at the moment.
So it's not a rule of international law, it's just your, an opinion of international law, that they don't extend that far, because it seems to be in some doubt in different jurisdictions, different rules prevail.
Well, there is a rule of immunity against execution. So it has boundaries, and injunctions are not within those boundaries. There is a rule, as we discussed yesterday, against criminal or financial sanctions. That has boundaries. Injunctions are not within those boundaries. So that then puts to one side immunity against enforcement and the related criminal or financial sanctions immunity. One then subsequently comes to consider whether injunctions are either just in a middle ground or are instead within the restrictive doctrine. But I am going through the process that way, i.e. eliminating from relevance the immunity against execution before I then come to the restrictive doctrine.
I follow. At that stage, you'll deal with the question as whether they may fall within the other procedural privileges.
Yes. So, tab 64 of the authorities bundle, please, page 1624. These are draft articles now from 1986.
Page 1624 is blank.
Oh.
Well, I mean, it's just a heading.
Yes. So that's the document, and then the text is at 1625. And at this stage of the drafting, the relevant article was 26 and entitled, I'm in the right-hand column, middle of the page, immunity from measures of coercion. A state enjoys immunity in connection with the proceeding before a court of another state from any measure of coercion requiring it to perform or to refrain from performing a specific act on pain of suffering a monetary penalty. So the rule had been modified to make it relate only to measures of coercion requiring a state to perform or refrain from performing a specific act on pain of suffering a monetary penalty. So at this stage, the connection is still being made to the extent that if the measure is on pain of penalty, then it is one from which the state is immune.
But why is this not a measure of coercion requiring it to perform a specific act on pain of suffering a monetary penalty?
Well,
where's it going to say in the order that there's no penalty if you don't comply? Is it, I mean, are you envisaging an order that says you must not proceed with proceedings in Curacao, but there'll be no penalty if you don't?
This is not where the UN ends up. This is a stage in the process of the drafting committee.
Right. Okay. No, sorry, I interrupted.
Yes, and as is helpfully pointed out, what the committee here was concerned about was the specific concept of astreinte in the French system, namely where there's a rolling penalty, a daily fine or damages that are due for as long as a party does not comply with an order of the court.
Where is the final document?
So we are coming to that, but I do say it's important to see how one gets there, but I am taking it as quickly as I can.
I'd just like to see it, if I may.
Article 24 is on page 1097.
Thank you.
So it's volume 3, tab 31.
You carry on, I just wanted to have a...
The judge also quoted the final article in the judgment, if that's more convenient, to have open simultaneously, which is at paragraph 109. So next one moves on to the draft articles in 1991. And the parties rely upon this for different purposes. Venezuela rely upon Article 23 as it stood at this stage on page 1629 to show there's a general prohibition in customary international law on the threat of criminal or financial sanctions. We rely upon it to show that one can distinguish between the order to perform or refrain, aka the injunction, and the consequences it entails, i.e. enforcement thereof. And so the committee was working towards what becomes the final Article 24 that makes that distinction. The draft articles were 1991, that is page 1631, behind tab 66. And in particular, please, page 1632. And here, the same point is being relied upon by both parties, i.e. we say that the drafting committee is starting to establish the clear distinction between injunctions on the one hand and enforcement on the other hand, whereas Venezuela say it shows the prohibition on threats of criminal or financial sanctions. And then one moves to the convention itself, which we pick up in volume 3, tab 31, page 1089. And while we are here, so we don't have to come back to it, can we please look page 1095, article 18. So this is state immunity from prejudgment measures of constraint. No prejudgment measures of constraint, such as attachment or arrest against property, may be taken in connection with the proceeding before a court of another state, unless and except to the extent that the state has expressly consented, or, over the page, the state has allocated or earmarked property. And what one then has in Article 19 is the distinct position from post-judgment measures of constraint. No post-judgment measures of constraint, such as attachment, etc., may be taken except with consent, allocated or earmarked property, and now also C, it has been established that the property is specifically in use or intended for use by the state for other than government non-commercial purposes. And so what Article 18 and 19 do contemplate is, in certain situations, that there could be relief which is in substance equivalent to freezing relief, albeit pre-judgment it's in 2 contexts, and post-judgment it's in subject to 3 conditions. For present purposes, Article 24 is making, we say, clear-cut the key distinction between injunctions and consequences. Any failure or refusal by a state to comply with an order of a court or of another state enjoining it to perform or refrain from performing a specific act, or to produce any document or disclose any other information, shall entail no consequences other than those which may result from such conduct in relation to the merits of the case. In particular, no fine or penalty shall be imposed on the state by reason of such failure or refusal. So at that stage, there was the express contemplation of injunctions, and the immunity is being delimited as an immunity against sanctions other than the consequences which may result in relation to the merits of the case, and then in particular fines or penalties as sanctions.
Is that addressing final relief? I noticed that the heading is privileges and immunities during court proceedings. Is it intended to apply where the order to perform or refrain from performing a specific act is the relief sought and is made at the end of proceedings?
Well, we do see how there could be an ambiguity there, but we say that in particular in circumstances where post-judgment measures of constraint are contemplated, which can go beyond those pre-judgment, because they can also be measures of constraint against non-sovereign property, it would, construing the articles as a whole, not then make sense to say that Article 24 wasn't permissive of post-judgment enjoinder. The Article 19 post-judgment measures of constraint are one type of injunction that could follow, and we say that at the moment we're just saying that the distinction is clear between injunctions and their enforcement, and we don't accept that this is only addressing interim injunctions.
One of the interesting questions though is that as a matter of domestic English law, the courts have considered the nature of an anti-suit injunction going back to the Angelic Grace, Donahue and Armco, Turner and Grovett, Lust, Common-Gorse and AES. I don't think we've got those authorities before us, but the gist of those is that what the court is doing is enforcing the exclusive jurisdiction clause or the arbitration clause. And of course that's not a matter which is going to be tried. It's a matter which will be determined on usually a Part 8 claim. Very often there will be an initial injunction granted and then a return date. But it is regarded, and Lord Hopp has said in Turner and Grovett that contractual arbitration or exclusive jurisdiction clause will provide such a ground for seeking to invoke the right to enforce the clause. It is seen as enforcement that's the House of Lords in Ulster Common-Gorse endorsing that.
And we don't shy away from that word being used there, but one has to understand that that is language about enforcing a contractual right, which can equally be used in respect of any such right at the adjudicatory stage of jurisdiction. One can award damages for a breach of contract, and one is enforcing the contractual right when making that award of damages. One can award an anti-suit injunction for breach or threatened breach of the right in an exclusive jurisdiction clause. One is enforcing the contractual rights. So we don't say that when this issue, in those different contexts, when this state immunity issue isn't being considered, that the use of the word enforce is decisive or even perhaps relevant. And it's a similar submission to that I'll make when I do come on to the Oldcombe case, which is that they haven't gone into the detail of this issue because it didn't arise. And so we don't accept that it is relevant enforcement in the context of international law. Next, the position in Australia, please, to which the judge refers at paragraph 113 of the judgment, and on which Venezuela rely at paragraph 24(3) of their skeleton. The judge's comments at 113 and 115 that Australia was taking an independent line have to be understood in the context that was in 1985, so it predated what we've just looked at in respect of the UN Convention. So I, like the judge, have taken these out of chronology.
Do you accept the validity of the first sentence of paragraph 115?
Sorry, which paragraph?
The first sentence of paragraph 115.
Yes, up to a point, because what we say when I get to the end of ground 2 is that injunctions are caught by the restrictive doctrine based upon the available materials under customary international law and as a matter of principle for the reasons that I've been developing yesterday and this afternoon.
Well, then they have to be adjudicative.
Yes.
So, and I thought it was reasonably clear that if there's no settled view, there's no principle of customary international law.
Well,
so he's wrong. I mean, you must say he's wrong.
When one understands the restrictive doctrine properly, and when one then analyses what an injunction is, by reference to the English law I've looked at, by reference to the customary international law I'm now looking at, then the answer is that injunctions are within the restrictive doctrine. But what I don't say is that there's an enormous amount of detailed analysis of why injunctions fall within the restricted doctrine. I'm not going to overstate the position by saying that. But what I am going to say is that injunctions aren't different from other remedies at the adjudicatory stage, and that therefore, just like other remedies at the adjudicatory stage, they come within the restrictive doctrine. And I do say that's what underlies the distinction that's being made in Article 24 of the UN Convention. Let's look at how it was dealt with in Australia, because there we do have the benefit of...
So it seems to me you are saying the first sentence is wrong in relation to injunctions, because you're saying that it comes within the settled view of customary international law as to the restrictive doctrine applied to adjudicatory jurisdiction. But what I really wanted to ask you is, do you say the same for specific performance? Do you say that equally there'd be no immunity from an order for specific performance against the state of a contractual obligation?
I do, because it follows in terms of principle from what I say about remedies, but I would again caveat that by saying that there will be the Article 24 divide. So it won't then lead to consequences such as criminal and financial sanctions if there is a failure to comply with the order for specific performance. So if one then turns, please, in authorities for tab.
So does Article 24 itself reflect a principle of customary international law that only applies to 22 states? Article 24.
One takes this in stages. In terms of the enforcement immunity, what I am showing is that there is nothing that extends it to injunctions. So that's my first aim. And to that extent, we say that there is settled practice that the enforcement immunity doesn't extend to injunctions. When one then comes, as I say, to the question of whether injunctions are floating in the middle ground or are within the restrictive doctrine at the start, then I have to accept that there isn't the same amount of material, and I'm building on the material I have and then allying that with what I say is a point of principle as to the adjudicatory jurisdiction.
If I've understood it, you're saying it does reflect a rule of customary international law insofar as it says the imposition of sanctions does attract immunity, but it doesn't reflect a rule of customary international law so far as enforcement without sanctions. For that, there's the gap in the same way as there is the gap in relation to customary international law in enforcement generally, and you say that gap is filled by the restricted doctrine in relation to adjudicatory jurisdiction. I understood your submission.
Yes. So Australia, one picks this up at tab 42, please, and page 1318 is the Law Reform Commission, where Professor Crawford considers this distinction between injunctions and their enforcement, and says this at paragraph 136, remedies other than seizure of property. So far it has been assumed that the successful plaintiff in an action against a foreign state would seek damages. The issue has been which property of the foreign state.
So it's my fault, I'm not aware.
Sorry,
which
page 1319
1319, thank you.
in tab 42. No, my fault, I'm going too quick. So far, it has been assumed that the successful plaintiff in an action against a foreign state would seek damages. The issue has been which property of the foreign state is able to be seized to meet the damage award. But courts have power to grant other remedies. Consideration has to be given to whether remedies such as injunctions, including interlocutory and moreover specific performance and orders for the recovery of property should be available against foreign states. There's a complete absence of discussion or decisions in civil law systems on this question, because this is before the UN start addressing it via the Special Rapporteur and the Drafting Committee. The United States legislation contains no provision, and we can then see a contrast between the US House report and Hansard, which we'll come back to. And at 137, the Commission then sets out its view. In general, the Commission believes that a court with jurisdiction over a case should be able to make such orders, including interim or final orders, and orders of a procedural or substantive character, as are appropriate and otherwise within power. This extends to remedies such as injunctions or orders for specific performance against a foreign state, even though the main method of enforcement of such orders against the state, attachment of foreign state officials to the state, may be an award of damages in default. Although such provision does not appear in any of the overseas acts, the power to make orders of this kind is, it seems, available at common law, and so one has the footnote 93 then referring to the common law position before the State Immunity Act, which is in the Trentex and Hispano cases. The basic principle is that if jurisdiction is permissible, it should, in the absence of special circumstances, be possible to make it effective. However, two qualifications to this general principle should be made. First, as has been pointed out, it is not appropriate to subject foreign state officials to committal or to fine them for failure to comply with orders. This should be made clear in the legislation. Secondly, it is desirable to restrict plaintiffs in employment contract cases against foreign states to monetary remedies and to exclude orders in the nature of reinstatement. So one has there, we say, the correct position of principle as to the adjudicatory jurisdiction, namely that it extends to remedies which are not damages but are injunctions or specific performance, but then one stops short of the criminal and financial sanctions. And that distinction is then illustrated in the Act, which is at the next tab, starting at 1321. On page 1338, in part 3, which deals with service and judgments, one then comes finally to section 29 on page 1341, subject to subsection 2, which is employment reinstatement. A court may make any order against a foreign state that it may otherwise lawfully make, unless the order would be inconsistent with an immunity under this Act. And then over the page, please, on 1342, one has part 4 on enforcement. And here, after property-related sections, 1344 has section 34. A penalty by way of fine or committal shall not be imposed in relation to a failure by a foreign state or by a person on behalf of a foreign state to comply with an order made against the foreign state by a court. So as I said yesterday, the issue, we say, is whether the existing structure of English law allows for the distinction that's been made by the Australian legislature and by the UN Convention on State Immunity. And we say it does by distinguishing an order of injunction from its enforcement. And Venezuela say it doesn't because contempt is inherent in the injunction. So the third international law material to show on this distinction between injunctions and enforcement is the Basel Convention or the European Convention on State Immunity. The judge refers to it at 112. Venezuela rely upon it at paragraph 24.4. And we have it, please, in Authorities, Volume 3, at tab 27. Article 18 says on page 987, a contracting state party to proceedings before a court of another contracting state may not be subjected to any measure of coercion or penalty by reason of its failure or refusal to disclose any documents or other evidence. However, the court may draw any conclusion it thinks fit from such failure or refusal. So on one view, that's neutral on injunctions. Venezuela say, together with the explanatory report to this convention, it shows that the penalty of contempt was deemed impermissible. And we'll look at the explanatory report in a moment. While here, so we don't have to come back to this, can we please look at page 990, Article 23. That says no measures of execution or preventive measures against the property of a contracting state may be taken in the territory of another contracting state, except where and to the extent that the state has expressly consented thereto. So that's the enforcement immunity for property. The explanatory report is at tab 28, please, starting at page 996. And we pick up the point, please, at page 1110. That deals with Article 18, and Venezuela rely upon that passage. And we say that other sections of the explanatory report shows that injunctions were contemplated, and the judge didn't deal with this at paragraph 112 of the judgment. So if one turns back, please, to Article 9 on page 1005, this article provides that there shall be no immunity in proceedings concerning the rights and obligations of a state in or in connection with immovable property situated in the territory of the state of the forum. And then at the bottom, it explains that Article 9 covers inter alia. Over the page at subparagraph 4, proceedings arising from the unauthorised use of immovable property, including actions in trespass, whether an injunction is claimed or damages or both. So the explanatory report accompanying the European Convention on State Immunity contemplates that in one situation at least there might be injunctions. So those are my submissions on the nature of injunctions as orders and the distinctions between injunctions and their enforcement, which we say is clear where it is addressed under both English law and customary international law. The second issue is then as to the extent of the immunity from enforcement under customary international law. And we say that this is an immunity principally concerned with state property. As I indicated yesterday, we accept that there is an enforcement-related customary international law rule making a state immune from criminal and financial sanctions, but we don't accept three different points. First, we don't accept that that immunity relates to threats of criminal and financial sanctions. The expansion to characterize a rule conferring immunity from criminal and financial sanctions to one conferring immunity from threats thereof is an exercise by Venezuela to try and elide the grant of an injunction with its enforcement. And we say that doesn't have any support in customary international law. Secondly, we don't accept that an injunction would fall within any such immunity relating to criminal and financial sanctions. The injunction is not itself a sanction. I've made that point already. Thirdly, if it arises, we don't accept that an injunction is even a threat of criminal and financial sanctions. So the starting point is to recognise the two distinct state immunities, immunity from suit and immunity from execution. And the latter relates, we say, to state property, albeit it has started to be eroded in respect of property used for non-commercial purposes and where the state consents. So I'm going to refer to 6 authorities delimiting the immunity from execution, although we've seen many of them already, so I can just list some of them. So number 1, we haven't seen, which is the Christina, and that is in Authorities Bundle 1, tab 2, page 22, please. And in this case, the Spanish government had requisitioned and taken control of a Bilbao registered ship that was lying at Cardiff. The ship owners claimed in rem for possession. The Spanish government sought to set aside the writ because it impeded a foreign state. The writ was set aside, and it was set aside because it was contrary to the rules of international law that 1, a party cannot impede a foreign state, and 2, process cannot be levied against property owned or in the possession of, in that case, a foreign state. And here at page 27, please, starting from the second paragraph, Lord Atkin explains the foundation for the application to set aside the writ and how it invokes these 2 distinct immunities. And the second, as highlighted by the bar in the margin, relates to the immunity from process against property which is the state's or in the state's possession or control. And then it is highlighted in the next paragraph that these are 2 distinct immunities appertaining to foreign sovereigns, but at times they tend to become confused. The second authority helping delimit the immunity from execution is the ECHR, or the Basel Convention, Article 23. We don't need to look at that convention again. It was Authorities 3, tab 27, page 990. The third authority is the UN Convention. We looked at that. I took you through Articles 18 and 19 a moment ago, dealing with pre-judgment and post-judgment measures of constraint against property which have eroded the absolute immunity from execution. The fourth authority is relied upon particularly by Venezuela, and that is in Authorities Bundle 4, tab 54. It is the textbook by Xiaodong Yang on state immunity in international law. It is important because of the focus on terminology again.
Page.
And one starts, please, at page 1507. And measures of constraint is a generic term covering both interlocutory, interim, or pre-trial measures prior to final judgments and the execution or enforcement of judgments. These are coercive or enforcement measures taken by the state court either to restrain the foreign state in the disposition of its property, normally in the form of interlocutory injunctions, or otherwise to attach, arrest, or seize the property of the foreign state. Such measures serve the purposes of either guaranteeing payment of debt or of satisfying a final judgment. So we say confusion can creep in and has crept in because measures against property can sometimes be generically referred to as measures of constraint, which label might make it appear as if the general immunity against enforcement extends to all injunctions, constraint and restrain not being so obviously distinct. And we say they are legally distinct when measures of constraint is being used in this way. Over, please, on page 1509, the author continues to highlight the importance of not being too attached to labels here. It becomes difficult to insist on a sharp dividing line between the terms immunity from jurisdiction adjudication and immunity from execution. It is important not to be misled by the terms used, and it is more than idle to be too preoccupied with them. It is necessary, rather, always to be clear about what stage of litigation and what concrete judicial measure one has in mind. And then...
Does he not mention anti-suit injunctions?
No, not from recollection.
Perhaps your juniors can check.
And finally here, page 1512, the two distinct immunities, as we saw from Lord Atkin, are being broken down. And the point is that, as in the second paragraph, even when a court decides that a foreign state does not enjoy immunity from adjudication, and even though the court then decides that the foreign state must pay a sum of money to the plaintiff, the court must still satisfy itself that certain conditions which are separate and wholly distinct from those pertaining to the adjudicative stage are satisfied before the assets can be forcibly attached or seized. And we say that's distinguishing the two stages of adjudication and enforcement, and remedies such as injunctions are in the first stage. The fifth of the six materials on this immunity is the Philippines Embassy bank account case, please. And that is Authorities 3, tab 29. And in this case, the plaintiff landlord had obtained judgment in default against the Philippines under a tenancy for providing office accommodation to its embassy. The plaintiff then obtained an attachment order against the embassy bank account.
Page, please.
1022. The Federal Constitutional Court held the attachment was impermissible where the account was used for sovereign purposes. The operative part of the judgment is excerpted on page 1026. And again, it shows that the focus of this immunity is on state property within the jurisdiction of the forum state. There is extensive treatment of the immunity against execution, starting at page 1040 and through to 1057, where the Federal Constitutional Court summarizes the result of its preceding survey at paragraph 6, halfway down the page. The above survey shows that there is no custom which is sufficiently general and is backed by the necessary legal consensus to constitute a general rule of customary international law, whereby the state of the forum is debarred outright from taking measures of execution against property of a foreign state situated in the state of the forum. And then on page 1060, finally in this case, the court said, while general rules of international law thus impose no outright prohibition on execution by the state of the forum against a foreign state, they do oppose material limits on execution. There is an established general custom among states backed by a legal consensus, whereby the state of the forum is prohibited by international law from levying execution on property used for sovereign purposes, except with the latter's consent. So that is, again, rather than starting with an absolute immunity onto which exceptions are grafted, saying that there is a more limited immunity from execution against sovereign property. Final case and sixth case on this immunity is the jurisdictional immunities from state decision of the ICJ. This same bundle, tab 32, it starts at 1101. We will then be going to 1150. Germany had applied to the ICJ for declarations that Italy was violating international law by not granting it state immunity in relation to claims based on Germany's violations of international humanitarian law during World War II. The specific issue, for present purposes, rose in relation to measures of constraint against German property in Italy. And we picked that up at 1150. At 1151, paragraph 113, the court observes that the immunity from enforcement enjoyed by states in regard to their property situated on foreign territory goes further than the jurisdictional immunity enjoyed by those same states before foreign courts. Even if a judgment has lawfully been rendered against a foreign state in circumstances such that the latter could not claim immunity from jurisdiction, it does not follow ipso facto that the state against which judgment has been given can be the subject of measures of constraint on the territory of the forum state or on that of a third state with a view to enforcing the judgment in question. They then refer to how waiver can be limited only to the former jurisdictional immunity, and then say that the rules of customary international law governing immunity from enforcement and those governing jurisdictional immunity, understood strictu sensu as the right of a state not to be the subject of judicial proceedings in the courts of another state, are distinct and must be applied separately. And they then go on to rule separately on the issue as to the German property Villa Vigoni in Italy. they consider Article 19 in particular of the UN Convention that we looked at before, and over the page at 1153, paragraph 117, refer to the long and difficult discussions, and 118, there is at least, it suffices for the court to find there is at least one condition that has to be satisfied before any measure of constraint may be taken against property, that the property must be in use for an activity not pursuing government non-commercial purposes, or that the state which owns the property has expressly consented to the taking of a measure of constraint, or that state has allocated the property in question for the satisfaction of a judicial claim. So in terms of the immunity from execution, and whether one starts with absolute immunity and works backwards or builds up for immunity for sovereign property, it is an immunity from execution which has always, we say, focused upon property. And so it doesn't touch injunctions. And against that background, one then comes again to the distinct sub-aspect of execution or enforcement, which is criminal and financial sanctions. We accept there is that immunity, but we say it doesn't do enough. And on this, there are a number of points in Venezuela's skeleton at paragraph 24, where they seek to build what they say is the threats immunity. And we can take them quickly because we have now looked at most of the materials. So core bundle paragraph 77.
What is the principle you're seeking to establish? That the criminal and financial sanctions don't include what?
That they are wrong to say, based on those
Who is wrong to say? I'm interested in the judge, Mr. Lewis.
Yes.
Was the judge wrong to say this, and if so, when?
Okay, well, setting aside Venezuela's paragraph 24, the judge was wrong in paragraph 115. It's back to the sentence about coercive measure against the state. And what Venezuela has done is they have sought to bolster that proposition by saying that is, when expanded, properly understood as an immunity from threats of criminal and financial sanctions. And the point I've been looking to make good, and I was going to finish on there, was that they have expanded it to cover threats when that's not grounded in the materials. And the materials, as I say, that they've dealt with in paragraph 24 are mostly the materials we've looked at, which draw the dichotomy in the way that the UN Convention does. And it's wrong, when one sees that dichotomy, to say, A, that coercive measures are a relevant description here that encompasses injunctions. And
what do we mean here by coercive measures? We mean measures which have practical adverse consequences, which encourage compliance.
Well, the judge doesn't
In
expand.
what sense do you use coercive?
Well, we say it's not a useful term to use in this measure, in this context, and we say it is better to refer to criminal or financial sanctions, but not threats of criminal or financial sanctions.
But why do you limit yourself to criminal and financial sanctions, as opposed to all sanctions in inverted consequences, commas, in the sense of all adverse consequences? The criminal and financial sanctions are simply one aspect of what makes injunctions coercive.
Well, if one uses coercive in that context, then we say injunctions are no more or less coercive than awards of damages and other remedies. We say they are simply the remedies granted at the end of the adjudicatory stage of a case. And one then begs a subsequent inquiry as to the consequences. And we do say that the language is important here, and one shouldn't just use a label like coercive measures and then use that as a basis to encompass injunction.
But that's the difficulty I'm having with your expression, criminal and financial sanctions. I mean, an award of damages at the end of an adjudicatory case in which there's adjudicatory jurisdiction involves financial sanctions, doesn't it, in the sense of financial consequences?
It does, but what I have done to try and narrow the issues is to, when Venezuela have recharacterized the judge's coercive measures as the threat of criminal and financial sanctions, to concede that there is an immunity from those criminal or financial sanctions. There's not an immunity from the enforcement of damages claims against non-sovereign property. We've seen that developing through all the materials we've looked at, ECHR, UNCI, and indeed, of course, in the State Immunity Act itself. And so at this stage, and this is obviously relevant depending upon the outcomes on ground 1 and will be relevant when we get to ground 3, it is important for me to ring-fence the enforcement immunities that do exist. And so I've done that by covering the two different aspects of those enforcement immunities. Execution against state property. I ring-fence that. It doesn't extend to injunctions.
Your whole thesis is based upon this concept that an injunction is just like any other order of the court by way of damages or declaratory relief, or whatever it may be. But help me with this. The courts in this country will make an order that a particular person shall not be removed on an aeroplane. Very topical at the moment. Something the government takes very seriously. But we know that there is a specific statutory provision that the courts cannot injunct the Crown. So what is the difference between an injunction which can't be granted and an order that somebody shall not be removed, which can be granted? And why is it that the latter is forbidden as a matter of statute?
Well, what we would say is that in substance, it is hard to see the difference.
Well, it plainly is regarded as a very important difference. The injunction is regarded as something you cannot order against the Crown, because that would be by way of coercion of the Crown, isn't it?
Could it be found in the Gypsy case, which you cited earlier? An injunction is all about expecting people to obey it. It is about obligation to do something. Is it not?
It is, but there is also an expectation that the judgment debtor will perform the judgment debt obligation.
Actually, there's rather not an expectation that judgment debtors will pay. The next stage is the enforcement stage, when you issue a warrant of control, or you attach earnings, or you go round and collect goods enforced against property by a bailiff. The judgment stage is simply an adjudication that damages are due. And by the way, you said earlier that they're due to enforce a right under a contract. They're not. They're due by way of damages for breach of a contract.
Secondary obligation.
But the enforcement is entirely separate from the damages adjudication. There are many, many millions of judgments. I happen to be head of civil justice, Mr. Lewis. I know quite a lot about the number of judgments that are given for money in this country every year, and the number that are enforced.
Well, but we embrace that distinction, but we say that injunctions aren't any different. It does come back to looking at this distinction as a matter of principle. And there may be a loaded aspect to the term injunction for English lawyers, but what we are trying to do is characterise them as a matter of international law. And when we do that, we look at the materials we've seen, the way that the UN Convention has dealt with it, and we see that they have said you can order someone, a foreign state, to perform an act or refrain from performing an act, and stop there. And so it may be that other types of injunction, where there's a penal notice attached and enforcement is directly in contemplation, could generically be described as coercive measures, because one is looking at the whole saga from start to committal. But what those materials show, and what we say English law is also set up to allow, is for an injunction to be granted with the consequences being a separate and subsequent inquiry. Now, that may not be the norm, but in Australia, one would assume the norm is that injunctions against non-states have penal notices or something and may lead to committals if there's not voluntary compliance. But the view has been taken, we say correctly, as a matter of principle, that one can just pull up stumps at the point of having made the injunction.
But you say the reason why the order should be made is because it does have coercive consequences, even in the absence of some subsequent proceedings. You gave, I think, as 2 of your 4 reasons this morning as to why there was a point in granting an anti-suit injunction, even if you did nothing further, that it had adverse consequences. And Venezuela, in their skeleton argument, draw attention to other aspects, such as the possibility of being debarred from being heard in other proceedings, being sufficiently wrongful act to form the ingredient of a unlawful means conspiracy, and so on. It's because the very making of the injunction is coercive in the sense that it has adverse consequences if you go no further, that it is in part a means of enforcement. It carries with it some element of enforcement.
If coercive means no more than potentially adverse consequences, then yes. I mean, the point about not being heard is a point about contempt that we understood was being made, a contemner not being heard, and the Ablyazov point about damages for contempt. But on our example, yes, I mean, being asked what's the point, I mean, one could ask the same to the UN committee, one could ask the same to Professor Crawford and the Australians. What's the point in having any of these injunctions when you're going to then pull your punches when it comes to enforcement? And we say that it has been understood that there can be consequences that nonetheless...
I'm putting to a slightly broader point, which I think is this, that why isn't it properly described as enforcement if it carries with it an element of sanction simply by being made?
Because if one characterises either enforcement or the phrase coercive measures that widely so as to cover any potential adverse consequences, then enforcement and coercive measures would become omnivorous and would consume all of the adjudicatory jurisdiction, because all the steps in the adjudicatory...
If injunctions are the same as damages, yes.
I do see the circularity there, but that's what we say.
That's what you say.
In that in every step on the road towards a damages judgment against a state can be coercive. I mean, one of the examples that I didn't give, but which could be given is it can enhance the prospects of settlement. And I mean, does one say that's coercive? The more one moves towards relief against the state, whether on a damages claim or on an anti-suit injunction claim, one is coercing the state to come to the table and negotiate. And so we do say that the terms enforcement and coercive measures lose any usefulness if they are allowed to expand.
Can I put this to you, Mr. Lewis? Injunctions stop people doing things, anti-suit injunctions particularly. But there are other injunctions where people are injuncted from going on land.
Mm-hmm.
Imagine the defendant standing on the edge of a piece of land and an injunction is granted by the court saying, you, Mr. Smith, must not go on the land. Is it not coercive when granted because it stops him putting his foot forward, knowing that if he puts his foot forward there will be consequences? And it's exactly the same with an anti-suit injunction. It says, do not proceed with this case. If you put your foot forward, there will be consequences. It's inherent in the nature of the relief.
We don't accept that.
The court is saying don't. You see the point?
I do. It begs the question as to the adverse consequences. And in that case, one would imagine a penal notice. And
but that's why I asked you earlier whether, now, forget the penal notice, which is, as you told us, just a warning. But is the order going to say there will be no consequences, which effectively says don't pursue the proceedings, but if you do, it doesn't matter?
No, it's not going to have the opposite of a penal notice, but it is going to be understood, if my submissions are accepted, based upon the judgment ring-fencing the appropriate immunities and the consequences, that any adverse consequences are limited. And we say...
They're limited, but the whole point of making an injunction is to, in colloquial language and in fact, is to stop someone doing something, which is by its very nature, I would suggest to you, is by its very nature coercive.
But for what reason are we asking this question?
Well, it's essentially different from damages, which you say it's the same as.
Well, I do, and we're going to come on to the restrictive doctrine, but in terms of the immunity from enforcement and immunity from execution, I do say that there's no support in the customary international law materials other than the State Immunity Act and the few statutes,
other statutes
which copied the State Immunity Act during a window in time between 1978 and 1985 before the UN started looking at the question. And there is nothing other than
that doesn't lead to consensus, does it?
No, but here the boot is...
You say he's wrong when he says there is no consensus.
But here the boot is on the other foot. There is no consensus that injunctions are caught within a coercive measures.
You didn't say there was.
Well, yes, and I'm back to where I was. That is how Venezuela interpret the judgment.
I know you know that I'm very interested in Venezuela's submissions. I've read them. I haven't sent a barrister to argue them, and I'm even more interested in the judge's judgment and why it's wrong.
And there are then three other customary international law materials to look at or highlight here, and they are the positions in Israel, Japan and Spain respectively. So Israel we have in Authorities Volume 4 at tab 47, and here one has page 1385, chapter 3, section 15, immunity of the foreign state from execution proceedings, and all that has been emphasised is the point about criminal and financial sanctions, not anything wider in respect of coercive measures. The next tab has the Japanese Act on the civil jurisdiction with respect to foreign states. That starts at page 1388, at page 1396. And that is to similar effect, Article 22. And then Spain is tab 50, starting at page 1407. And then moving on to 1449, please. And here in the translation, it says the fact that the foreign state or the international organisation fails or refuses to comply with the requirement of a Spanish jurisdictional body urging it to carry out or refrain from carrying out a certain act, to present any document or to reveal any other information, will have no consequences other than those resulting from such behaviour in relation to the substance of the matter. So it's the same as UN Convention Article 24, and albeit in translation, obviously, it's put in terms of urging rather than coercion.
Machine translated by Google. I wonder whether we like those kinds of translations.
Yes. So we deal with this in our supplemental skeleton at paragraph 24. I won't read that out further. But before we leave the immunity from execution and enforcement, I want to address the English authorities on the framework of the State Immunity Act, and this is paragraph 91 of the judgment. And we say those dicta cannot be decisive on how injunctions are to be characterised under customary international law. And that's what matters. And we haven't got this phrase, coercive measure, under customary international law. So we mustn't be led astray by it. But the judgment at paragraph 91 and Venezuela rely upon these authorities, starting with Olcom at Authorities 1, tab 7, page 185. They rely upon these for the headline proposition that section 13.2a is about enforcement. And that, therefore, for them, brings it within the immunity conferred from enforcement. So here the default judgment creditor obtained garnishee orders covering the Colombian Embassy in London's bank account, and the House of Lords set them aside under the State Immunity Act. And the key passages are at page 205, please. Starting up at between B and C, the State Immunity Act purports in Part 1 to deal comprehensively with the jurisdiction of courts of law to adjudicate upon claims against foreign states, to enforce by legal process enforcement jurisdiction, judgments pronounced and orders made in the exercise of their adjudicative jurisdiction. And then it explains how, although comprehensive, it doesn't adopt the straightforward distinction between sovereign and non-sovereign acts. In the next paragraph, Lord Diplock refers to the somewhat convoluted style of draftsmanship, providing for exceptions to exceptions. We saw that analysed by Lord Sumption as well yesterday. And then the key passage on which the judge relies. Sections 2 to 11 deal with adjudicative jurisdiction. Sections 12 to 14 deal with procedure. And of these, section 13.2 to 6 and 14.3 and 4 deal in particular with enforcement jurisdiction.
So that would be authority, would it, for the proposition that as a matter of English law, an injunction under 13.2 is dealing with an enforcement jurisdiction?
That is an obiter proposition to that effect. So 3 points here. A, Lord Diplock was not focused on any issue relating to section 13.2a. The focus was on the property-related provision of section 13.2b. Point B, we don't accept that this dictum can be decisive of where injunctions fall to be classified in the context of the 3 different immunities under customary international law we have been debating. It's not what Lord Diplock was addressing. And C, where his lordship goes on to say Admiralty jurisdiction may be regarded for the purposes of the Act as hybrid, we say that if injunctions were being analysed and if there was analysis of customary international law, then one might lead to the conclusion that injunctions were hybrid, to the extent that freezing injunctions could be said to relate to property, pre-enforcement, whereas other injunctions unrelated to property.
It might be said that freezing injunctions were not in the mind of the House of Lords in 1984 as strongly as they might be today.
No, and nor anti-suit injunctions. It may be said. The second case relied upon by the judge at paragraph 91 is the ETI and Bolivia case. That is in Authorities Bundle 2, tab 14, starting at page 436. The claimant investor in a telecoms company nationalised by the Bolivian government obtained an ex parte freezing order under section 25 of the Civil Jurisdiction and Judgments Act. It was set aside on the return date and the Court of Appeal dismissed an appeal relying upon section 13.2a State Immunity Act. And the passages relied upon are by the judge and Venezuela, I should say, are at page 461. Paragraph 113, where Lord Justice Lawrence Collings says it is plain that there is nothing in section 9, that's the arbitration provision, which overrides the prohibition in section 13. Proceedings for a freezing order to preserve the position pending execution of an award are within section 13 and are not proceedings which relate to the arbitration for the purposes of section 9. And then on page 464, the judgment of Lord Justice Stanley Burton says that halfway down, where injunctive relief is sought, the claimant must deal both with the immunity from the adjudicative jurisdiction of the court and with the immunity from enforcement. It is simply not open to such a claimant to complain that he is not in a position to deal with such jurisdictional issues on its application without notice, and this is even more so on an application on notice. So we do accept that in that case, generally, section 13.2a, when dealing with a freezing order, was approached as part of the enforcement jurisdiction, but we say that in circumstances where it was dealing with property, it was there, if there had been detailed analysis of customary international law, properly being said to be within the immunity from execution against property. But that doesn't address the question of injunctions more generally, nor is it decisive for characterisation of injunctions for the purposes of customary international law. The fourth and final authority here relied upon by the judge in judgment para 91 is the general dynamics case, which we have at the back of this bundle, authorities 2, tab 21, page 675. And General Dynamics sought to enforce an ICC Geneva arbitration award against Libya in England in the same manner as a judgment under Section 101 Arbitration Act. The question was whether service of an enforcement order had to be through diplomatic process under Section 12.1 of the Act. It was held that was a mandatory method, and we're going to come back to this on ground 3. But for this purpose, reliance is placed against me on paragraph 30. And there, as to the scope and effect of section 12.1 SIA, there is, again, a general paragraph, we say, dealing with or giving an overview of the Act, which just doesn't engage with the detail of the issue we're currently debating. When dealing with the service provision, it's said that the present case does not directly concern immunity from adjudicative or enforcement jurisdiction. Sections 12 and 13 confer procedural privileges. So we say that we have demarcated the immunity from execution against state property. We have marginalised those authorities relied upon at paragraph 91, which are just giving a bird's eye view of the Act without engaging with this customary international law question. And then we revert to my Lord Lord Justice Phillips' question yesterday about why anti-suits aren't anyway covered by the immunity from execution against property because of the shows in action. So we say two things. One, an anti-suit injunction is not a measure of execution against property, i.e. the cause of action represented by the claim on the insurance contract. It does not constrain the defendant in the manner in which the defendant assigns or sells or mortgages or disposes of the shows in action, but requires by way of personal injunction that the defendant comply with the terms of the shows in action. The conditional benefit principle, as reflected in the case law considered by the judge at paragraphs 32 to 41, means that the rights themselves are qualified by the arbitration clause, or in this case, or jurisdiction clause in others. So Venezuela's quasi-contractual or equitable right is not a right to a claim anywhere, it is a right to a claim in London. And an anti-suit injunction adjudicates upon that right. Point 2, in any event, if an anti-suit injunction were to be regarded as a measure of execution against property, a claim on the insurance contract is a shows in action which, under English conflicts principles, is situate in the country in which it should be enforced, in this case England, because it falls to be enforced in London arbitration. The claim is, to that extent, if one is against me on the first point, a commercial asset for the same reason that assets of the state within London, tangible assets of the state within London are commercial assets. So, taking stock at this stage, if I am right on ground 1, then I say that on ground 2, the judge erred in holding that anti-suit injunctions are covered by the enforcement immunity, or more specifically by a coercive measures immunity, as recharacterised by Venezuela as immunity against criminal financial sanctions. But if your lordships are against me on ground 1, so that one has the Fogarty fallback before we get to ground 3, and anyway so as to frame the position properly before we get to ground 3. I do say that injunctions are covered by the restrictive doctrine. So that takes me to the third issue on ground 2, which is as to the extent of the immunity from jurisdiction and whether the restrictive doctrine extends to the orders or remedies a court grants. And we do say that the restrictive doctrine extends to injunctions relating to non-sovereign acts. And insofar as they don't relate to sovereign property, they don't trespass upon the immunity from execution against sovereign property. So here we say, as in our first skeleton at paragraph 45, when classifying injunctions under customary international law, it is wrong to adopt a one-size-fits-all approach just because that is what section 13.2a does. The extension beyond freezing injunctions, beyond measures of constraint, as Yang would call them, to purely personal injunctions unrelated to property and in respect of private acts, was simply the UK legislative technique in 1978. It's not determinative under customary international law. And we do say then that there are numerous materials which proceed on the assumption that injunctions related to non-sovereign acts do fall within the restrictive doctrine as a matter of customary international law, as the judge came close to accepting at paragraph 110 when dealing with the travaux préparatoires to the UN Convention that we've looked at. And the reason we say there isn't more detailed analysis of the question of whether personal injunctions unrelated to property fall within the restrictive doctrine is because it is a straightforward matter of principle that injunctions, i.e. orders to do an act, when one leaves aside the English law baggage that was discussed, are part of adjudication. It's my point about remedies again. Against that background, I want to list out 7 authorities, most of which we've looked at already, so we won't have to see again, which are premised upon and consistent with that assumption, namely that injunctions are within the restrictive doctrine. So 1 is the UN Convention, Article 24. And that's been given effect to, as we saw, we say, by Japan, Spain, and Israel. Number 2, the ECHR explanatory memorandum contemplating injunctions. Number 3, the Australian position. We've looked at that. Injunctions are dealt with. Then one pauses, take stock. Consequences are a separate, subsequent question. Point 4 is the position taken in the US. And for this, please, I do want briefly to show you the materials. Firstly, please, the Act itself, that is the Foreign State Immunities Act.
Do you accept US as an outlier, as the judge said?
No, because as we've seen, the UN Convention and the European Convention both...
The US goes further than the UN.
Where the US goes further is in relation to consequences, sanctions. So to that extent, yes. But in terms of the grant of injunctions, no. And so we have the Act itself in Authorities 3 at tab 37. And that starts, please, at page 1249. And the key provision is 1606 on page 1249. As to any claim for relief with respect to which a foreign state is not entitled to immunity under section 1605 or 1607, the foreign state shall be liable in the same manner and to the same extent as a private individual under like circumstances. And that grounds the injunctions that we've referred to in certain case law and is explained in the House report in the preceding tab at tab 36, starting at 1243, report of the Committee on the Judiciary, and the passage is at 1244. I'm told there is a repro error, so the words consistent with should not be struck through there. They are part of the original. I don't know why the red line is there. I'm sorry it is. Consistent with this section, a court could, when circumstances were clearly appropriate, order an injunction or specific performance. But this is not determinative of the power of the court to enforce such an order. For example, a foreign diplomat or official could not be imprisoned for contempt. Also, a fine for violation of an injunction may be unenforceable if immunity exists under sections 1609 to 1610. So again, whatever decision the US separately take when it does get to the question of enforcement, separate questions. Next and fifth item of 7, please, is the case at Authorities, tab 3, page 35, which is the decision of the Austrian Supreme Court in Hoffman and J. Drahl. And in chronological terms, this case is at the beginning. The Czechoslovakia had expropriated and nationalized the local branch of a German cosmetics manufacturer. The German company sought an injunction restraining the use of its trademarks in Austria, and the Austrian Supreme Court upheld that injunction. So in the Oxford reports here, it comes with a headnote which includes analysis on page 1194, so not part of the judgment, but commentary from 2018, and in analysis A1, it says, in this leading Austrian case of 1950, the Supreme Court relied upon the distinction between sovereign and non-sovereign acts and thereby adopted the restrictive state immunity doctrine. The Court examined numerous sources from a wide range of jurisdictions in an exceptionally detailed, almost exemplary manner. The decision has received considerable attention by international law scholars far beyond the German-speaking world. And then at A2, in formulating the grounds for its ruling, the Court proceeded in a highly structured way that reflected the hierarchy as regards relevancy of the quoted materials for determining custom. First, it outlined previous Australian judicial practice, and then it went through practice from many other jurisdictions. So the decision starts at 1200, and on 1201, the plaintiff had applied for a temporary injunction. That's paragraph 8. At the end of paragraph 9, his application for the injunction was granted by the lower court. Paragraph 10, it was then set aside by the Court of Appeal on the basis that restraint would only be possible if extracts from the trademark register showed an exclusive usufruct in Austria, but then, as we see about at paragraph 13, the Supreme Court reinstated the judgment, and so reinstated the injunction. And what one does not see is anything suggesting that injunctions are otherwise than within the restrictive doctrine. Paragraph 62 on page 1212, the court has concluded its analysis of the comparative materials and therefore reaches the conclusion that it can no longer be said that under recognised international law, so-called acta gestionis are exempt from municipal jurisdiction. Over the page, it's the trader commercial activity argument. While previously states didn't do much non-sovereign activity, today the position is entirely different. States engage in commercial activities and, as the present case shows, enter into competition with their own nationals and with foreigners. Accordingly, the classic doctrine of immunity has lost its meaning and ratione cessante can no longer be recognised as a rule of international law. So paragraph 66 and 67, the Supreme Court concludes that domestic jurisdiction must be found to obtain. The court then goes on to deal with the merits. And on page 1219, at paragraph 98, the court upholds or reinstates the lower court's grant of an injunction. The sixth authority to show is the textbook Fox and Webb, which we have in Authorities Bundle 4, please, tab 55, starting at page 1555. And if one then is on page 1555, please, the authors are addressing UN Convention Article 24, so we've seen this before. To that extent, over on page 1556. Well, before we get there, it's interesting to see the text at just below the article itself on page 1555. The ILC in its 1986 draft boldly stated that a state is not required to comply with an order by a court of another state compelling it to perform a specific act or to refrain from a specific action. But following criticism of such an invitation to openly flout a national court's order, i.e. an injunction, the final text considerably modifies the approach, and then we see the two-stage approach that was ultimately adopted. And over the page at 1556, in the passage marked at the top, injunctions given in the course of the proceedings relating to the adjudication of a claim may relate to the adjudicative stage, as where an arbitration tribunal makes an order relating to the conduct of the oral hearing or to conserve property pending the determination of an award. Now that actually goes further, because it's saying that one might potentially have an injunction which is in the nature of a freezing order. And we don't need to go that far, but we do say that injunctions are in contemplation. Seventh and final point here is a point arising from Ben Kabouche, for which we do need to return to that decision, please. And it's Authorities 2, tab 18. 576 is the start. And the point is that we say it's understood herein that remedies generally are covered by the restrictive doctrine unless there is a bespoke immunity for a particular remedy. The effect of Ben Caboose is to...
Where does it say that?
I'll go straight to the point, but it's quite dense, so I did just want to introduce it, if I may. The effect is to find that there will be a legitimate immunity in international law, i.e. under Article 7 of the Vienna Convention on Diplomatic Relations, from an order of the court requiring reinstatement of a mission employee. So what we'll see Lord Sumption say is that there is a proven immunity from that remedy based on a proven special rule under the Vienna Convention on Diplomatic Relations. But there is no special rule for remedies otherwise. So one takes it, please, at page 624, paragraph 69, and here Lord Sumption is dealing with section 16(1)(a), and over the page, well, starting at the bottom at paragraph 70, the Secretary of State submits there is indeed a special rule applicable to embassy staff. And over the page, reference is then made 6 lines down to Article 7 of the Vienna Convention on Diplomatic Relations. A sending state may freely appoint members of the staff of a diplomatic mission. In my opinion, however, down at letter C now, Article 7 of the Vienna Convention has only a limited bearing on the application of state immunity to employment claims by embassy staff. I would accept that the right freely to appoint embassy staff means that a court of the foreign state may not make an order which determines who is to be employed by the diplomatic mission of a foreign state. Therefore, it may not specifically enforce a contract of employment with a foreign embassy or make a reinstatement order in favour of an employee who has been dismissed. But a claim for damages for wrongful dismissal does not require the foreign state to employ anyone. It merely adjusts the financial consequences of dismissal. And we say the implicit premise is that the restrictive doctrine would otherwise cover the remedy of ordering reinstatement, effectively specific performance, but for this specific immunity on a proven special rule arising out of Article 7 of the Vienna Convention. And one sees that then reflected in the amendment that was made to the State Immunity Act following the Declaration of Incompatibility in Ben Caboose. So if one follows that through to the Act in Authorities tab 1, page 13, there has now been inserted section 2A, which is subject to subsection 3 below, where on a complaint under section 111 of the Employment Rights Act, the tribunal finds that a member of staff was unfairly dismissed. Relief shall not be given against the state concerned by way of an order under section 113 of the Act, which is reinstatement, aka specific performance. So that specific immunity has been found to exist by Lord Sumption for specific performance as a remedy in that context, and has then been grafted on to the State Immunity Act. And by equivalent reasoning, we say that absent a special rule of customary international law that all injunctions are prohibited, it follows that they are within the restrictive doctrine. And when one understands that injunctions are caught by the restrictive doctrine, one can then put section 13(2)(a) and the materially similar statutes in their proper context the question then becomes whether those statutes are a sufficient basis to crystallise a bespoke rule which derogates from the restrictive doctrine in the way that Article 7 did in terms of reinstatement of embassy employees. So, in summary, we say that injunction is simply one of the species of remedies that can be granted in civil proceedings, and that the restrictive doctrine is the relevant rule of state immunity for the purposes of applying the test in Benkabush discussed yesterday. Section 13.2a is, in principle, immunity from the grant of an order, so partial immunity from adjudication. Enforcement comes later in the event compliance is not voluntary. The answer, we say, lies in the fact that injunctions are when one avoids the trap of conflating them with sanctions, no different to any other court order for the purpose of the restrictive doctrine. And that's, we say, the answer on customary international law. If we're right that the restrictive doctrine applies, that's then also a complete answer on ground 3, to which I now turn. Ground 3, and we can take this more quickly because we've covered the customary international law materials, so I'll just be able to refer to them in passing. We say the judge erred by concluding there was an infringement of Article 6.1 by reference to legitimate domestic policy aim, and here we criticise paragraphs 117 to 124 of the judgment.
Sorry, give me those again.
117 to 124. So a threshold point is to consider the impact of the submissions I've made on ground 2. There are, we say, 2 distinct positions. First, if the court accepts my submissions that injunctions relating to non-sovereign acts are covered by the restrictive doctrine, then that rule, i.e. that application of the restrictive doctrine, is a rule the court is bound to apply such that it cannot justify Section 13.2a separately on grounds of domestic policy. If the answer under ground 2 has been that there is no rule of customary international law mandating immunity, but nor is immunity mandated by If the answer is that the restrictive doctrine doesn't cover injunctions, so I was wrong at the end of my submissions on ground 2, but I was right with my first 2 points, that nor do the enforcement immunity or the sanctions immunity cover injunctions, then there is no rule of customary international law to provide the answer here. And that's where we concede, as I said yesterday morning, that there is space for an alternative legitimate domestic policy aim. But even in that limited scenario, we do say that the space is necessarily limited because it covers many, if not all, the same considerations underlying the customary international law position that we addressed on ground 2. So the close relationship between these 2 inquiries as to customary international law first, or legitimate domestic policy aims by reference to international state practice secondly, is highlighted in Benkabush, again, by Lord Sumption at paragraph 68. So that is Authorities 2, tab 18, page 624, please. So this if I won't read out paragraph 68, but in the middle of the paragraph, Lord Sumption says, on the footing that international law does not require a state to be given immunity, I do not see how the absence of British nationality or residence at the time of the contract can be a proper ground for denying an employee access to the courts. And then at the end, nor do I accept that the only relevant interest for this purpose is that of the UK state. The forum state has duties as well as rights, and as a matter of domestic policy, they extend to the protection of those lawfully living and employed in the UK. So it shows 2 points. One, the lack of commercial international law justification for conferring an immunity is a key context into which we then enter this domestic policy debate. And 2, it is necessary to take into account the UK's duties, not just factors that are said to weigh in favour of immunity. And those duties include respecting the rights of those within the jurisdiction or who come before the UK courts, which extends here to the clubs.
I'm sorry, it's my fault. I'm just having some difficulty following how, if you don't get home on grounds 1 or 2, customary international law has anything, properly so called, has anything to say about it. We're now into the field of there is no rule of customary international law, there is simply a range of international practices. Now, I can see that if we're looking at domestic policy, you could say, well, if the range of international practices is overwhelmingly in one direction, but just short of sufficient to amount to customary international law, that might be a relevant consideration. Not sure you'd be right about that, but I can see that to be what you're saying. But that isn't what you've been seeking to persuade us, is it, in relation to customary international law?
Well,
you've been showing us a lot of materials in some places and indulging in an analysis that the only gap, as it were, is filled by the adjudicatory restrictive doctrine. Mm-hmm. If you're right about that, you're right about that. We never get to, you say we never get to ground 3 because Ben Carbuche says if there is a rule, you've got to comply with it. Mm-hmm. If we get to ground 3, there is no rule. Mm-hmm. Why are we then talking about customary international law at all? The hypothesis is no customary international law to be applied at this stage. It's just international practice.
It's international practice, yes. And what your Lordship has anticipated is what I'm going to say about general dynamics, that when one is looking at international practice and diversity, it is then a question of degree, as I said. And one may have a situation like general dynamics where one is close to a customary international law. It's a near miss. One doesn't quite have the substantial uniformity.
I think it would be good to develop this point in the morning. Mr. Lewis, how long have you got?
Well, as I said, I will definitely finish by lunchtime, and I will hope to finish ahead of that at some point during the morning. Rounds 3 and 4 are much quicker.
This was a 2-day case. I would have thought that your argument should be completed within perhaps a full day, but not a day and a half. So you'll consider that. And we have now looked at most of the materials.
Yes.
Good. Thank you. 10:30.